Tonight we're going to talk about closing the real estate transaction. Obviously, this is what we live for in our business as we want to come to closings. So what does it take to get to a closing? What's going to be involved from a law perspective to get to our closing? This is the final stage of the real estate purchase transaction during which the deed and the purchase money are exchanged. To a large extent, the contract governs the closing format. Some localities use escrow closing, where the deed and purchase price are delivered to a third party who is directed to close the transaction outside the presence of the parties. In other places, we have what we call a round table closing, where people come together, sit down together, and actually have a closing. Or you might have a closing at separate times where people still sit down with a closing agent and it's not just done through the mail. But more and more often we're using escrow closings because people can't get together. And so an escrow closing is a way to get it done, and it all still works. The broker, this is where they're going to show up. They have an economic interest in a closing. They usually participate in the closing preparation, and they're present at the closing. In order to do the closing preparation, they're there as a guide. They help the buyers or the sellers get their paperwork or get their houses, quote, in order so that they're ready to go to a selling. And very often the listing agent, listing broker is present at the closing because this is where they're going to pick up their commission check. But in our Ohio market, we really don't run the closing process. We just attend. And again, it's because where we're going to get our check to be paid, and usually it would be the listing broker, listing agent. But very often the buyer agent might be at the closing as well. Again, they're there to hold the hands on support and make sure that everything closes and everything gets done. Attorneys. Their roles vary according to state law, type of closing, local custom. Ordinarily, attorneys explain the documents such as the deed, the abstract or title insurance policy, the mortgage note, and the closing statements in advance. Occasionally, the attorney has a more important role if the problem arises. But in our closings here in the Cincinnati area, typically it's a closing agent. It's not an attorney that's present. Now, if you go to a commercial closing, yeah, there's going to be an attorney there all the time, and there might be two attorneys there representing the buyer and representing the seller. But in our residential market, more than anything, it's just a title clerk. It's somebody that's there. They've run a bunch of closings. They can pretty much go through all the process. They can explain pretty much anything that's happening with the documentation. This is the person who's most important. It's the settlement clerk. They're the person who's designated to coordinate the execution of the documents at the closing. Like I said, these settlement clerks do many closings on a given day. They've been through the process before. They know how to explain all the documents that are required. The buyer's preparation for closing. They're going to obtain financing. They're going to examine the title. They're securing their hazard or insurance policy. Basically, it's for the property and liability insurance. They're going to determine what they need, how much they need at the closing. Typically, that's a cashier's check at a bank, and very often they're going to find out an hour or two before closing and then go get that check. And then very often they want to inspect the premises. There's some kind of inspection prior to the closing, whether it's the morning of the closing or a couple hours before closing. They typically want to walk through the house to make sure that it is as they thought it was going to be for the closing. The seller's preparation for closing, they're obtaining evidence of title. They've been in contact with the title company to prepare documents or get whatever documents are needed to obtain the evidence. They've prepared the deed. Typically, this is the title company doing the deed. They're removing encumbrances. They're gathering utility bills and receipts, only if they're going to turn things over to closing. But very often today, if I'm going to buy a house, I can contact Duke Energy and I can get a history of what the bills are. Duke Energy is going to want to know who I am as the new customer. I'm going to have to give them some information about me so that they'll open an account in my name. So whether I have utility bills or not, as the buyer, I'm going to have to go through this process. And then the sundry certificates or whatever they're leaving with the property. If they're leaving a range or a refrigerator with the property, do they have the operations manuals? Do they have some kind of warranty certificates or something that they want to turn over at the closing? So sundry certificates, anything else that they're going to leave at the house and they want to give the buyers to help them along in the process. The seller's actions at the closing is to tender the deed to the buyer or settlement clerk for delivery, provide evidence of title in the form of an abstract or attorney's opinion, sometimes called the certificate of title or title insurance. Very often, you're going to get a title commitment, and the buyer wants to see that title commitment to know that they can get title insurance. The seller is going to make sure the title commitment's available. The purchaser's actions, they're going to tender the purchase price to the seller, usually by some form of, like I said, cashier's check. Most closings involve two distinct but related transactions. The sale of the property is closed between the buyer and the seller receiving the purchase price, buyer receiving the deed, and then what it comes down to is really the loan is extended by the lending institution, is closed between the lender and the borrower, with the borrower receiving the proceeds of the loan and the lender receiving a note, a mortgage from the borrower securing repayment of the loan. So the seller pays off the old mortgage and the seller's lending institution cancels the old mortgage. And again, this is where you want to look for that satisfaction of mortgage on behalf of your sellers. The Real Estate Settlement Procedures Act. This is something you want to know for your test. It's called RESPA, Real Estate Settlement Procedures Act. It's a federal law that requires lending institutions to disclose certain information to purchasers of residential real estate and prohibits those institutions from engaging in specified activities. So the things that they require is full disclosure, what's going to happen with the loan, how much is the loan really going to cost somebody. And one of the things the RESPA was trying to do is 24 hours in advance of a closing, have a closing statement ready. As realtors today, we just kind of close our eyes and go, sure, right. Usually the closing statement is ready a couple hours before the closing. And this is where they're going to have you as a realtor look over the closing statement. Again, you'll learn this through going to enough closings, how to prorate costs, what should be done, how to do some of the basic math for this proration, but to look for all the costs to go where they're supposed to go, whether they're the buyer costs or the seller's costs, what happens on that closing statement. The Home Loan Toolkit, every lender is required to provide an applicant for a mortgage loan with a copy of this booklet. So my son went through Quicken Loans to get a loan on his house a little over a year ago, and after he did that, Quicken Loans got him a home loan mortgage, this toolkit, to be able to learn what the mortgage is all about. It's consumerism, it's teaching the consumer what they're doing when they're applying for a home loan, what they're buying. The loan estimate. The loan lender has to provide the borrower with a loan estimate from which integrates the old preliminary truth in lending and the good faith estimate forms into one for easier consumer reading and understanding. Again, what is the loan estimate? What's the cost of the loan? How much will principal and interest payments be? When you get to the closing, they're going to tell you that $150,000 home all of a sudden is now a $400,000 home after you've made your 30 years worth of principal and interest payments. You're going to have a little heart attack at that point in time, and you're going to feel like they turned you over and shook you out and took everything from you, but that's all part of this whole truth in lending, telling you everything that you're borrowing. The lender has to provide the form within 3 days of the application for the loan, this true loan estimate. The lender must also provide disclosure to the applicant that the loan servicing may be transferred or assigned if that's the case. Old new lenders must notify the borrower in advance of the actual transfer. Years ago, I went to a closing, and right at the closing, I signed transfer documents, and they sold the loan literally right after the closing was done. So this can happen pretty quick because, again, we're dealing with the origination loan in the marketplace, then the loans get put on the secondary money market to be sold. Otherwise, lenders would run out of money. So they're always selling their loans so that they can keep lending money. The inspection closing disclosure form. The previous Truth in Lending and HUD-1 forms have been integrated into one form for easier consumer reading and understanding. It has to be available, again, to the borrower 3 days before closing. Not always the case. The HUD-1 is typically a day to a couple hours before closing. This is the true closing document where you see all the costs prorated. Again, all of these forms and the way they're done is standardized across the country, because the loans are packaged and sold across the country. And in order to do that, they've got certain documents that are all in place for these loans to be sold, so that this whole origination process is all done similar. If you work in the lending industry, you see the same loan paperwork from bank to bank, from credit union to credit union. Wherever you're dealing with, whoever's doing these loans is dealing with the same type of paperwork. Abusive practices. One reason Congress passed RESPA was because certain abusive practices had inflated closing costs. Kickbacks are an example of an abusive practice. In other words, realtors were getting kickbacks. Realtors were getting paid fees for bringing lenders, paid fees for home inspections, for recommending home inspectors, for recommending different services, title companies, title insurance, things like that. And so what they basically said is we're no longer allowed to get these extra kickbacks. As realtors, we can't get this extra money for these referrals. And so they want us to be open and upfront about this. If there's money involved, everybody has to know all the way around that there's money involved if there are referral fees being paid. The easier way to deal with this is we kind of got rid of them. We're not doing that part of the business anymore, and that's fine. Post-closing procedures. After closing, the buyer has the deed recorded to give constructive notice to the world of the new ownership and thus protect the buyer against rival claimants. It's also that the mortgage wants to get recorded right at that very moment in time as well, so that the mortgage can be protected against other lenders or liens. Satisfaction of the pre-existing mortgage should also be recorded. It must be recorded, and you also want to try it again as the salesperson. Get proof of that and give that to your seller so that they can keep that document with their house paperwork. What will happen is years from now, banks get bought and sold, and all of a sudden that recording that wasn't maybe recorded as thoroughly as it should have been, somebody's going to come back looking for that piece of paper. It's always better and easier to have it, again, with your house papers if you got it. And then ultimately, that's how we wrap up this lending process and the legal aspect of what goes on at a closing.